Bryan Kohberger, the man accused of murdering 4 University of Idaho students in their off-campus home, is going to plead guilty. That's according to several new reports, and one family of one of the victims is confirming that information, and they are not happy. I have all of the details in this breaking episode of Crime Fix. Welcome to Crime Fix. I'm Angenette Levy. We have breaking news in the case of Bryan Kohberger and the murder of those 4 University of Idaho students. Bryan Kohberger has apparently agreed to plead guilty to 4 counts of murder and 1 count of burglary for the murders of Madison Mogen, Kaylee Gonclaves, Ethan Chapin, and Xana Kernodle in exchange for the death penalty being taken off the table in this case. News started circulating about this on social media earlier today. And then the Gonclaves family, the family of Kaylee Gonclaves, they confirmed this information in a Facebook post, and they are not happy about it. Take a look. The Gonclaves family said, "It's true. We are beyond furious at the state of Idaho. They have failed us. Please give us some time. This was very unexpected. We appreciate all of your love and support. Hashtag heartbroken. Hashtag Kaylee Jade forever." Now, this news comes as Bryan Kohberger was preparing for trial. This was a death penalty case, of course. The state of Idaho was pursuing the death penalty against Bryan Kohberger since 4 students had been murdered. It was a horrific case. It shocked the world. It also shocked the small town of Moscow, Idaho. Bryan Kohberger had been maintaining his innocence in these murders up until now. DNA linked him to the crime scene. A single spot of DNA linked him to the crime scene. It was found on the inner snap of a K-bar knife sheath. That knife sheath was left next to the leg of Madison Mogen. Madison Mogen was one of the 4 victims, a beautiful, beautiful young woman, a blonde beauty found in her bed, stabbed to death next to her best friend, Kaylee Gonclaves. Ethan Chapin, the boyfriend of Xana Kernodle, she was found stabbed to death as well, as was Ethan. Ethan was found in Xana's bed, and Xana was found on the floor in her bedroom. 2 roommates survived, and they have been the subject of much speculation and harassment, but hopefully that ends now. News of this guilty plea comes right after Judge Hippler, the judge presiding over the case in Ada County, denied Bryan Kohberger's request to continue the trial. He wanted to delay it because of pretrial publicity. There's an Amazon Prime docuseries coming out next month, along with a book and other materials that might be coming out as well. There was also a massive leak of evidence to Dateline. So we're going to be following up on this for you in the days and weeks ahead. This is a Law and Crime legal alert. If you've received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. Morgan & Morgan is actually investigating claims that patients were not properly warned about this risk. It's free to check. It takes just a few minutes, and you don't pay unless Morgan & Morgan wins. So scan that QR code on your screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. One thing that's so interesting to me is the fact that we were talking just in the last week or so about the defense in this case wanting a continuance because the defense said, we're simply not ready. Take a look. Kohberger's lawyer, Ann Taylor, has been his lawyer since his arrest in late December of 2022. And she says she and Kohberger's defense team, they're simply not ready for trial. She talked about this at a hearing last week.
Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized.
Taylor has talked before about receiving 68 terabytes of discovery from the prosecution, but the prosecution says much of that is irrelevant. Then Taylor pointed to the media coverage and the Dateline episode that aired last month with information that hadn't been known to the public previously. Dateline claimed Kohberger searched pornography about forcing sex on women who were sleeping, that he searched Google for serial killer Ted Bundy, and that he also searched for news about the murders and his name. Dateline also aired selfies Kohberger took where he wore all black.
Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while.
Now, Judge Hippler had suggested last month that he wanted an investigation into the person or people who leaked this information. We'll have more on that in a bit. And Taylor also said she needed more time to investigate Bryan Kohberger's life history to prepare for a possible penalty phase. The new special prosecutor on the case responded to that and Taylor's other arguments.
We have a life history for the defendant. The defense has amassed significant materials, and I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance, and to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game.
So let's get into what Judge Hippler had to say about Ann Taylor's arguments about not being able to review discovery. Hippler wrote, "The court found defendants' complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. Then Hippler addressed the whole issue about needing more time to conduct a life history investigation. Hippler wrote, "The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence." We're going to get to what Judge Hippler had to say about the defense's argument about pretrial publicity here in just a moment, but I want to bring in Josh Ritter. He is a former prosecutor at the LADA's office, currently a defense attorney, and the host of Courtroom Confidential on YouTube. Check it out. Josh, your initial thoughts on Judge Hippler denying the defense request for a continuance?
I'm not surprised at all. I mean, one, we got kind of a preview of this last week when the judge made those comments in court that, listen, I haven't made up my mind. I haven't written a decision, but I would encourage everyone to go ahead and plan as though we were starting trial on the same date that he had indicated earlier. And the reasons that he give are kind of the reasons we all suspected. Yes, the defense wants more time, but they haven't really articulated a reason for that. It's one thing to say, we need more time to prepare. Well, you've been saying that for quite some time. What makes this different? What changed? How are you somehow prejudiced? How is this somehow going to affect your case? And the judge said that essentially that was not articulated enough for him to feel that it was overriding to the concerns for justice, because the people and the victims in this case have a right to have this case heard too. They don't need to have to wait an endless amount of time for this to come to trial. So I think the judge did the right thing, and it's also not surprising.
That's interesting to me that you think he did the right thing, because Ann Taylor kept saying, this is a death penalty case. This is a capital case. Death is different. We need more time to investigate things. But I want to put up on the screen everything the judge says they've got. They've got all of this stuff they've looked into, military records of his father, his pre-K or kindergarten records through his PhD records. They've interviewed former teachers, a former boxing coach, all of these different people. I mean, there's a lot that they've investigated so far. And the judge is basically saying, in order to protect his rights, you don't have to investigate every nook and cranny of his life. It just has to be reasonable. And you've done a lot of investigation already. They were saying, we have to do more. There's these red flags. And the judge is like, no, there aren't. There really aren't any red flags.
Yeah, it's not a small point to say it's a death penalty case. And of course, it has been treated differently. And I think the judge has given a lot of deference to the defense in this case. But how far does that go? It's not endless. It's not an endless amount of continuances just because it's a death penalty case. And I think he's been hearing this same argument from Ann Taylor for a while now, and he's starting to go, listen, we're talking about going close to 3 years now since the murders took place. That is a tremendous amount of time. Yes, this is a very serious case. Yes, it's a case serious both to the victims, their families, and to the defendant. He's looking at the possibility of the death penalty. But at the core of it, if you really think about it, this case is not all that complicated. What I mean by that is this. We're not talking multiple defendants. We're not talking several different crimes that took place on several different days where we might expect the complexity to grow exponentially. We're talking about one evening. Now, the loss of life was tremendous, but it all took place on one evening by one perpetrator. That is something that, as far as factually, you can get your head wrapped around in pretty short order. Getting close to 3 years is plenty of time for that. Yes, to your point, they could probably spend another year investigating and trying to turn over every unturned stone. But eventually the judge has to say enough's enough. It's time to go.
And he also said, you've said got the 68 terabytes of evidence, but, you wait until the last minute to file for a continuance. You don't bring this up until now. You didn't ask for more help. You didn't ask for a team of paralegals to help you go through this stuff. And much of what you were given in that 68 terabytes is irrelevant. And you've filed tons of motions in this case. I mean, he knows he's dealing with really competent attorneys. Yes, I'm sure they would love more time. But he's saying, guess what? This is where the rubber meets the road. You should have brought this up earlier if you were having all of these issues. It's time to do this.
One more thing to think about here is that it might not be as much that the defense feels like they need more time as they feel like they need to make a record that they need more time. What I mean by that is correct. They're always thinking about appeal, especially in a death penalty case, and preserving these issues. And the issue of ineffective assistance of counsel doesn't necessarily mean that your attorney did a bad job, that your attorney was incompetent. It can mean that your attorney wasn't given enough time to adequately prepare. Well, you can't make those arguments if those objections are not in the record. So it could be just more of this kind of, I don't want to call it a show, but it could just be more performative for the purposes of appeal than it is really a request that they need the more time to actually be prepared and ready.
Let's talk now about the big elephant in the room, the Dateline leak and the pretrial publicity. First, we've got the Amazon Prime documentary coming out in just less than 2 weeks from now. So that's hitting Amazon Prime, and that's going to feature Ethan Chapin's family, witnesses in the case, and Maddie Mogen's family, her mother and stepfather. Then we've got a James Patterson book coming out. But then we've got the Dateline leak, where information was leaked to Dateline that nobody knew about, at least the public didn't know about, regarding the Google searches attributed to Bryan Kohberger, the selfies where he's wearing all black, things of this nature. Wearing all black, looking like the person that the surviving roommate DM described walking through the house without the mask, at least, searching for Ted Bundy, all of these different things, having photographs of the friends of the victims, there's a lot there. I mean, it was prejudicial, according to Ann Taylor. The judge said that he wanted an investigation, and he signaled, that a special prosecutor should be appointed to look into this. But I want to put up on the screen now what he is saying. He's basically saying now that, pretrial publicity, we're going to do voir dire. We're essentially extending jury selection another week to do this. And he has mentioned in the past that they may have to sequester the jury. But he's saying there's no proof that delaying the trial is going to do anything to alleviate the effects of pretrial publicity on the case. And then he writes about this investigation, the investigation that he kind of said he wanted. In addition, even assuming it was law enforcement who leaked the information, the FBI played a preeminent role in the investigation of this case. If the leak or leaks were from the FBI, a state court's ability to further investigate is highly circumscribed and limited, if not altogether foreclosed. In addition, law enforcement in Pennsylvania and Washington may have had formal or informal access to some of the evidence, yet an Idaho state court may have significant limitations on the ability to investigate them. That almost sounds like he's saying, hey, my hands are tied here. We may never find out who leaked this. I've talked to many people who think that you can find out who leaked this. So what's the deal here? I mean, he's not going to delay the trial to try to find out who the leaker is. He said that. He said it's speculative. He's not going to delay a trial and hold the trial hostage based on an investigation into finding a leak. But he's almost saying, like, we may never find out, and the FBI was involved in this case, and I can't investigate the FBI.
I got to tell you, I really like this judge. I think he's very thoughtful. I think he's very fair, too. And that's what I like about him. But I also think he's right on this point. Here's what he's saying. He's saying, one, a delay is not going to change the leak. In other words, giving you more time doesn't change the fact that information's out there. So how does delaying the trial cure any of this? Really, what it creates is problems for jury selection, which are always going to exist. it's going to cause the attorneys to have to question jurors more about what they know. Have they watched this Dateline episode? Do they know about the leaked information? Has that affected their ability to be a fair juror or not? That's the real issue. And so the delay is really, comparing apples to oranges in his view. The other thing he's saying is, as far as the investigation goes, is even if the leaker were discovered, that doesn't necessarily change or alter the integrity of the evidence or what the evidence is. In other words, we could find that person out, but we're still going to be dealing with the same evidence that we have here. So therefore, again, a continuance isn't going to do much to address any of that. There's one point I'll come back to that is a nightmare scenario dealing with that. But then finally, he's saying, and this is something I hadn't even really thought about, he can assign a special prosecutor. He can give them subpoena rights. He can say, go out there and investigate. That doesn't mean that the FBI is going to open up their doors. And if this quote unquote leaker happened to be within the FBI, they may come to a end here that has no end, where they just don't know who the leaker is. And given that uncertainty and indefinite timeline, he's again saying, I can't delay this based on the idea that maybe, perhaps, someday in the future, we might find out who this is. Now, getting back to the one nightmare scenario I imagine, I hope this is not true. I can't see this being true, but I could see there being a problem if the leaker is determined to be someone closely connected to the investigation, someone in law enforcement, someone who collected evidence. That could be a problem.
That's what I think. And that's where I think the defense, let's say that's the nightmare scenario, the doomsday scenario, then the defense should be able to cross-examine that person.
Absolutely.
If that is the case, they should be able to question that person. But, Judge Hippler kind of suggested that earlier on that it's likely somebody on the state side, or at least that was his suspicion. Now he's leaving the door open, saying basically, but it could have been somebody on the defense side. So he's kind of like walking that back a little bit. He's leaving it open to the fact that somebody on the defense side could have leaked it. So we'll see. He's saying trials going forward. He's now extending the voir dire period from August 4th to through the week of August 11th. So we're going to have now 2 weeks for jury selection. Opening statements pushed back to August 18th. So 2 weeks to select a death qualified jury. That's a significant amount of time.
It is a significant amount of time. Maybe that was kind of him, a compromise saying, I do believe that the biggest problem we might have here is with jury selection. So let's give us a little bit more time to do that. Also, when you're selecting a death qualified jury, it's just going to take longer because you have to go through the entire panel and weed out those who say, for whatever reason, religious, moral, or otherwise, that they would never vote for the death penalty. You've got to get rid of all those folks. It just takes a lot more time, and it's a much more serious case. So they're going to take longer with each individual juror. So I think 2 weeks is probably enough. I wouldn't be surprised if towards the end of it, they're asking for more time, but I think they could probably get the work done in that period of time.
Let's turn now to the judge's decision on the alternate perpetrator. I like to just call it the some other dude did it evidence. Judge Hippler slammed the door on the defense on this stuff. The defense wanted to point the finger at 4 suspects. Their names are all redacted. We have a lot of black, a lot of redactions here in the paperwork, in the judge's order. And basically, there were 3 people that the defense singled out. They presented this evidence under seal to Judge Hippler. These are people who were in the social circles of the victims. They had interacted with some of the victims at parties and things like that before the homicides, and at least with one of the victims. And there was a 4th person who apparently noticed one of the victims at a store shopping 5 weeks before the murders, went to approach her, and then turned away before, he could talk to her. This was captured on surveillance video. The judge is saying basically, look, all of these people cooperated with the investigation. They gave DNA samples. They let the cops look at their phones. They cooperated. They have no connection. And under the case law in Idaho, the Meister case, there has to be a connection. You have to be able to show a connection in order to point the finger at people. And this is the case law in Idaho. So he's saying basically, right now, you haven't shown me enough to do this. Your thoughts on that, Josh?
Again, I think he's spot on. I mean, the biggest thing that the judge is concerned with in making this ruling is that we don't want to confuse the jurors. It's one thing to present alternate theories, but it's another thing to just throw up anything that looks suspicious and hoping that that confuses the jurors. And that's the decision he had to make. And according to the case law in Idaho, you are correct. You have to point out that there is, beyond some sort of just suspicion, that there actually is evidence that connects this other person, this alternate perpetrator, to the crime. But beyond that, you have to show that even if you feel someone else may have been implicated, how is that person exculpatory to the defendant? So yes, we've even heard, and I thought we were going to hear more about this, but apparently they went with other theories, but we even heard about, unidentified male DNA being found in other parts of that home. Well, just because you found other unidentified male DNA does not mean that Bryan Kohberger's DNA is not on the knife sheath, or it does not mean that somehow Bryan Kohberger may not be involved according to the police. So it's one thing to say other people could have been involved, but are they involved to the exclusion of the defendant? And he didn't find any of that exists here. Instead, you're left with something where it just could be confusing to jurors. Now, that all being said, this doesn't take away the argument from the defense about if they want to say that this investigation was a rush to judgment or myopic. They can still say, well, didn't you receive all these other tips? And you didn't investigate those tips, did you? Or you really found Bryan Kohberger and then you just forgot about all the other information. They could still kind of cross-examine investigators and present those arguments, but they cannot specifically identify another person and say, this person's good for it, and the police didn't look at that.
Yeah, he's really shut the door on where they can go, the avenues of the defense. So jury selection, August 4th for 2 weeks, then opening statements on August 18th. I'll be there in Boise, Idaho. Josh Ritter, thank you so much for your time as always.
Thank you so much for having me.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.